Good afternoon. Welcome to all our viewers to another Plus website. Today's website is on aligning customary land and water tenure reform in South Africa, lessons from Africa. Just to contextualize the website, what we are talking about is that South Africa and the rest of Africa, in terms of customary land tenure, this has received wide-scale policy and action in terms of scholarly and scholar and research, whereas tenure rights to water and customary land has not received as much attention. What is worse also is that the permit systems continue the colonial era practices of overriding customary water tenure for domestic water uses, livestock, irrigation, water under customary, and also fisheries and other small other uses. So what we are going to do in this webinar is to explore the rights-based legal tools that can support water resource allocation to meet human rights and support living community-based water tenure in line with constitutions of the countries in Africa. Today I've got three presenters. Jessica Trowell, who is a senior attorney and director of International Water Program at the Environmental Law Institute, a Washington-based organization, but she's based in Harare. I've also got Dr. Barbara van Koppen, who is the scientist emerita at the International Water Management Institute, and Patience Mukuyu, who is a researcher and a PhD candidate at the International Water Management Institute. I'm going to give each of the three speakers 10 minutes. Each has prepared a PowerPoint presentation for their inputs. So what we are going to do is to start viewing those and then give our viewers and also listeners chance to engage with them after they have presented their inputs. I'll start with Jessica, and Jessica is going to talk about the link between land and water tenure and legal recognition of customary tenure, water tenure, in terms of the global perspective with examples from Africa. Jessica.
Thank you so much, Mafa. And thank you all for joining us today. I'm waiting to see, my colleague Barbara is going to put up, here it comes, the slides. Fantastic. Thank you, Barbara. I'll be focusing today, as Professor Hara said, on the legal aspects of customary water tenure in particular. First, looking at how it fits into the broader legal recognition of water rights, water tenure rights of both Indigenous peoples and local communities, but then specifically focusing in sub-Saharan African countries on the ways that those countries are legally recognizing and protecting communities' customary water tenure rights. This work is based on a longstanding project that my organization, the Environmental Law Institute, has been doing in partnership with the Rights and Resources Initiative originally, and now with IMI, the International Water Management Institute, to develop a globally comparative analytical framework that tracks the legally recognized freshwater rights of Indigenous peoples and local communities. These efforts culminated in the publication of a report called Whose Water?, which analyzed the national laws of 15 countries across Africa, Asia, and Latin America, and looked specifically at these community-based or collectively held freshwater tenure rights. This is really a critical area of focus because approximately half of the world's land is customarily stewarded by 2.5 billion Indigenous peoples and local communities. The community-based tenure systems employed by these communities regulates access to and use of natural resources on at least half of the world's landmass, including over 60% of the land in sub-Saharan Africa. Yet only about 10% of this land is legally vested with those communities, which significantly constrains their ability to pursue locally adapted livelihoods and to protect the vital resources that are contained within their land and territories. That said, over the last 2 decades, we have made important progress in terms of advancing legal recognition of land and forest rights of communities. For example, forest tenure rights. Indigenous and local community advocacy around those rights has resulted in an increase in the global forest area owned by and designated for communities by about 40% in the last 12 years. However, comparable advances with respect to community-based freshwater rights still haven't taken place. Water tenure itself is an evolving concept and hasn't been consistently applied to the situation of communities or customary rights. The specific rights that are most essential to community freshwater security aren't really widely known or accepted, and until now, the legal recognition of community-based freshwater tenure rights has yet to be widely tracked over time. So this is what we tried to do in order to fill this gap. ELI and RRI developed this water tenure tracking methodology to apply a bundle of rights approach that defines community-based water tenure regimes as an interrelated set of freshwater rights that, when held by communities as rights holders, can form the basis of their water security and promote community livelihoods, cultural vitality, and sustainable development. Next slide, please. I won't go into too much detail about our methodology, but this sort of encapsulates, you can see the legal indicators in the middle there, and those are the bundle of rights that we broke down to see what laws we're protecting. And we also, I think, broke down, I think importantly within this context, the legal recognition of customary rights, as well as different levels of use rights for communities. We looked at domestic uses, but we also looked at legal rights to use water for livelihoods purposes. We also contextualized the consideration of our legal indicators by looking at whether those were dependent on the legal recognition of land or forest rights, as well as whether the countries we looked at recognized the human right to water and women's specific rights to use and govern community waters. Next slide, please. So probably the key finding that we had from this work is that communities' freshwater rights are dependent on their legally recognized land or forest rights in over 60% of the community water tenure regimes that we identified. In some countries, this land-water nexus, as we're calling it, serves as the only source of legal water entitlements for communities. And this is significant for a number of reasons. First, the water tenure regimes with a land-water nexus tended to also provide more consistent recognition of a wider range of community-based freshwater rights than those that were not based on a nexus. So for many communities, the ability to realize a full suite of water tenure rights can't be adequately undertaken if their land and forest rights are also not legally recognized and secure. Second, the ways in which the nexus is created under national laws are extremely diverse, from land, forest, agricultural, water laws across many sectors. And this really highlights the need for improved legal harmonization to ensure tenure security for communities and to support more integrated resource planning and management. In so many cases, we looked at the sectoral laws fail to speak to each other or even contradict one another. And ultimately, this can really undermine the security of communities' land and water tenure rights. Next slide, please. So as I said, we also specifically looked at the national level, whether laws were recognizing communities' customary water rights. And the security we found of communities' land and water tenure rights in many countries hinges on the interface between customary laws and government issued laws, that may or may not recognize those customary rights. 82% of our 39 community-based water tenure regimes actually do recognize communities' customary water rights, but the recognition is rarely specific to water. It's almost always based on land rights or territorial rights that include water within that broader definition. So based on these initial findings, ELI and the International Water Management Institute tried to unpack and further explore the ways within sub-Saharan African countries in particular, how those countries are legally recognizing customary water tenure rights in their national laws. I should note a couple of things really briefly before discussing these findings. The first is that we did focus our research on national level, or in some cases, subnational laws, state-issued laws, and did not have the opportunity to systematically address the implementation of those provisions. We do recognize that these laws are often created and passed without appropriate consultation with communities and can even be at odds with the practices of those communities. The second critical thing is that while we're looking at the legal recognition of customary rights, we also don't mean to imply that communities' tenure rights emanate solely from those laws, or that states possess the only legitimate right to grant, revoke, or deny those rights. However, the legislative provisions that we studied often form the basis for how well customary water tenure rights can be upheld in the face of increasingly competing uses and users, and therefore provides what we think is a critical aspect of strengthening and making more equitable and plural legal systems that can support communities' customary water tenure rights. Next slide, please. So in looking at this national level recognition, many countries in Africa, in fact, 33 out of 52 African constitutions, refer to customary law in some form, but they also widely vary in terms of the specificity of how well it's recognized. And almost never, as a matter of fact, I don't think I've ever seen a specific constitutional recognition of customary water tenure. I have seen it of land tenure, though. These are some examples. In Malawi, the Constitution recognizes existing customary laws as having the force of state law, except insofar as they're inconsistent with constitutional provisions, and also prohibits customary provisions from gender discrimination. In Namibia, similarly, both the customary law and the common law of Namibia are recognized to the extent to which they do not conflict with the Constitution or other national level laws. So this is kind of a common formulation at the constitutional level. It doesn't get specific, but it provides a broad-based recognition of the legal status of customary law. Next slide, please. So as I noted, the land-water nexus provides the basis for the recognition of many community-based water tenure rights. And in fact, water laws are seriously lagging behind land and forest laws in terms of their recognition of customary water resource rights. And this often poses problems, as I said, where these don't speak to the provisions in other sectoral laws. So our findings were that customary water rights are recognized in only 64% of the community water tenure regimes without a land-water nexus, but in 92% of those tenure regimes that had a nexus. So it's quite a big difference. There are some notable exceptions that we can learn from in terms of water laws that are specifically recognizing customary laws. In Namibia, their communal, well, I have to say this is actually a land reform act. It's not a water law, but it does specifically recognize the customary rights and practices in relation to water courses specifically. In Mali, their water code requires all private appropriation of water, so including licensing, to respect customary rights recognized to rural population. And they also have a pastoral charter that addresses the rights of pastoralists in the country that recognizes their customary water rights and legally protects their primary access use rights. So they prioritize their access use rights to certain water points without requiring them to ever get a permit or pay a fee for it. And then interestingly, in Kenya, they've started to legislate at the county level. And in certain counties, including Turkana County, where there's a high level of pastoralist population there, they also specifically protect pastoral livelihoods by prioritizing water for those livelihoods above everything else, all of their water uses, except for domestic water uses in the county. I guess I would just say before we move on from this slide that, again, this really, the fact that these rights are often so deeply embedded within this land-water nexus that they come from land laws, that they come from forest laws, that they come from pastoral laws, means that there's a job to do in terms of ensuring that we're harmonizing tenure recognition and protection. Otherwise, we see inconsistencies or contradictions that can undermine the rights of communities. Next slide, please. So water, land, and environmental laws can also be leveraged to protect customary water tenure rights by enshrining due process rights, or rights to prior notification and consultation with communities, and allowing them to appeal when certain activities or proposed activities or licenses are potentially threatened by third parties. So, for example, Namibia's Water Resource Management Act requires the ministry to have regard to existing water uses by traditional communities, and to take into cognizance the extent of customary rights and practices whenever a license to abstract or use water is applied for. Similarly, Malawi's 2013 Water Resources Act requires consideration of any traditional community or customary rights that are dependent on water resources where an application for a permit might impact that water resource. And across many countries, environmental impact assessment provisions can also provide this kind of procedural safeguard where proposed activities can come in and impact a community's customary or community-based water rights. Next slide, please. So what can we do? These are just a few suggestions for sort of focusing on the key legal gaps that we've noticed. One is, again, more comprehensive recognition of customary water tenure rights across different sectoral legislation and harmonizing those provisions. Another is, and this I think my colleague Barbara will get into, prioritizing livelihoods-based water rights and customary water rights, and tailoring administrative requirements, such as for permits, so that communities have an easier time of accessing and using water for sustainable livelihoods. Legally prioritizing, such as they did in Mali, communities' access to water for their customary uses, strengthening due process requirements, such as those that were just outlined. And then importantly, something I didn't have a chance to get into, I know I need to wrap up, is providing specific protections for women's customary water governance rights to address gender inequalities in community decision-making. And with that, I will wrap up, and thank you so much.
Thank you, Jessica. That was quite rich and extensive. Without any hesitation, can we go to Barbara? Barbara is going to talk about evidence of living customary water tenure in Africa. Barbara.
Thank you. Thank you so much, and welcome also to all listeners. In my presentation, I will show what is happening in terms of living customary water tenure. It's a big word. So across Africa, what do we mean by it? And then we really talk about the bottom of the pyramid, every household and the small-scale farmers or life pastoralists who have managed their water resources since time immemorial, living, not whether recognition or not, as Jess mentioned, is a different issue, but this is happening on the ground, where I'm sure that you have experienced yourself. If you really ask communities, what are your multiple water sources? How do you get it to your homestead or to your fields? And what does it mean for your well-being? That people can quite easily make these maps. They know how they get their water for the multiple uses. And you probably, when you talk with water people, we talk about the infrastructure. If you see the picture on the left-hand corner, there is a difference between getting the water from the resource to your homestead or to your field or to your livestock, and the resource, the little river or the groundwater resources. So there is a lot of attention to alleviate the tasks of women or men to get the water where you need it. And there is a lot of attention then to climbing the water ladder in terms of infrastructure development. And it's definitely not only government who is making water supply systems for domestic uses or irrigation systems. On the contrary, we see that in low-income rural areas, people have to do it themselves. Government isn't there, and they do it. And development of affordable technologies, even solar and solar energy or pumping, really makes it more affordable and accessible for everybody to to get really a lot of irrigation and domestic uses where people need it. So that is, and another example is that you can either do it as individual or even together. You can organize in your village here in Chakuma in Vembe. 11 subgroups have organized themselves to buy pipes, to tap into the mountainous streams, to get the JoJo tanks for storage, and then to distribute the water to every household, which is another example of informal self-supply. People invest in the infrastructure. But that is different from the resource, the little stream. Who owns the little stream in villages? And I would really remember the fantastic work that Barbara Tapela has been doing on the customary water tenure, also in terms of sharing the resources. And that, we still build upon to better understand, okay, now who owns the little stream or the big stream in the rainy season? And there the issue becomes very much the sharing of the resource. Have the upstream people always the priority, or the ones who have the deepest well, a deep tube well, are they the ones who can suck the aquifer empty? So for the resources, the naturally available resources, surface, groundwater resources, the question is really in the sharing. And this notion that water resources are shared is a commons is very strong in rural communities. And there it helps to talk about sharing in. So that is within a community that manages its land resources, but also its water resources and its forest and its livestock, etc., and vegetation. So how does a community at that level share the water resources? And then the big thing is that I'm born or married in a village, so I have the water of that village that is linked to the territories of the village is also partly mine. Of course, communities, they stimulate people generally, including the chiefs. Please invest in infrastructure. We want to improve our livelihoods. There is also this notion that the domestic uses have a priority. Even if there is not so much, then the irrigators, they can only irrigate a little bit, or maybe they can't irrigate at all, because the domestic users have the priorities. And in this way, when there are problems, for example, everybody tries to get the pipe a bit higher than the other one in the mountainous stream, because then you get the bigger stream. But then there are arrangements. You can go to the chief and you can find the rules. Well, let us do that. If you have your pipe here, then all the new people who are investing in infrastructure, because that is the biggest change in the sharing of the resources, all the new investors in the infrastructure have to go below that. Then we see also that between customary communities, there are also rules. And then we call that the sharing out with neighboring communities, which are also governed by customary arrangements. And for example, the same rule that you can't have your pipe higher than the other one is another example that even holds for communities. Or the downstream communities, they go with and sit with the upstream communities and say, can't you do it during the day and leave the stream in the night to come to us? So you get a rotation. And there are many examples here from South Africa. Here, this is Vembe as well, where these rules exist. And of course, the fisheries, and Klaas has done fantastic work on the fisheries as well. There are also ways in communities to organize themselves for the fisheries as well. And then moving to the right, the most right picture, the real problem is the powerful third parties, the external people who just come and put their pipe wherever they want, or dig the deepest, the sharing out with powerful third parties. And there, in South Africa, of course, the distribution of water resources is enormously unequal. There we really get the problem that the majority of the people, the number of users at the bottom of the pyramid, even together, they hardly use any of the water resources. I'm not talking about the water resources, but it is the few big users who really take almost everything. And there we get then the debate. How can we call it a hybrid water law, that the regulatory licensing, so any new big company that wants to invest in infrastructure, make a dam or get groundwater, before they even have their plans, any construction in the planning process, as Jess also mentioned, there should be due process. What are the impacts on the customary water tenure? And so that is, for example, MSS there's a lot of debate on that at the moment in South Africa, the big companies can just pick it, because customary water users in former homelands are not recognized, and patients will continue on that. So we really say for the big ones, the few big ones who use a lot, they can't. They have to be regulated very clearly, and if they don't use their water, they can't trade it. It should go back to the state, to the government. While at the bottom of the pyramid, where there is really so important that at least the resources should be safeguarded, prioritized for not only domestic uses, the basic human needs reserve, but also for the small-scale productive uses. And then very much as Jessica has been analyzing for national legislation, the customary arrangement should be recognized and very much linked to the land where the people live. Thank you.
Thank you very much, Barbara, for quite an illuminating talk on the living customary law. Next is Patience. Patience is doing some work in Komati, and her talk is on how living customary land law is overridden and how it should be legally recognized in South Africa's National Water Act, evidence from Komati catchment. Here the issue is that the National Water Act somehow does not fully recognize the customary land rights. Patience.
Okay, thank you so much, Mafa. I'm going to share my screen and hopefully you'll be able to see it. Okay, all right. Okay. Okay, it looks like I might have lost my my screen sharing abilities, but in any case, I will just email this to Barbara now, and if she's able to share it for me, that would be great. Barbara, I'm sending it to you right now. So good afternoon, everyone. And just picking up from the conversation that has already been started by Jessica and Barbara, really showing the linkages between customary water tenure and other resource tenure regimes. I'm going to take you to the local level where I've been working as a PhD student, as well as under a research study that we're doing with the Water Research Commission, looking at customary water tenure and how it's recognized in the Nkomati catchment in South Africa. So really the story starts with the historical imbalances that exist within that catchment. We have been looking at the Sand catchment, which has the former homelands of Gazankulu and Lebowa, And here we have villages that were dispossessed of their customary land. And there are a lot of existing lawful water users who are the big water users within that catchment, and who are mostly white, who have control over large volumes of water. So even today, as we speak, those historical water entitlements are still being recognized within this catchment, and they take up a lot of water. And customary water tenure, on the other hand, is not explicitly recognized within the National Water Act. So one provision in the National Water Act that looks at dislodging these historical existing lawful water uses that were given to white settlers is the compulsory licensing process. And since independence, really since the promulgation of the National Water Act in 1998, compulsory licensing has been happening at a very slow pace. So which essentially means that existing lawful water uses are still continuing to be recognized for white water users. At the same time, there is no similar explicit recognition of customary water uses within the Inkomati catchment and in South Africa in general. So the compulsory licensing process would allow that when existing lawful uses are dislodged, it allows for the setting aside of water for the historically disadvantaged. And so slowing down this process really makes it difficult to set aside water and to redistribute to those who were dispossessed of that resource during the colonial period. So when we look at the entitlements that exist for the customary water users, who are mostly small water users within the National Water Act, we find that the regulations or provisions that are available to be applied within customary water uses are very weak entitlements. We have entitlements such as Schedule 1, which really looks at domestic water uses. These are small uses which are not supposed to be commercial, so you can only use them around your household to water your garden, but not to sell. There are arguments around this. Some would say that one can sell a little bit so that they can have some form of livelihood, but actually in the Act itself, it says no commercial use is allowed under Schedule 1. In the general authorization entitlement, which is also available to be applied in customary water uses and also recognized as one of the redistribution tools, we find that it has been given a very low threshold. So currently it equates to about 0.2 of a hectare, which is quite small compared to what we are seeing on the ground. The average size of a plot of land for most of the water users we're seeing is about 1 hectare. Some even have 4 hectares. So we find that in terms of entitlements that apply to water users at this scale, they are very weak compared to perhaps the existing lawful uses, which are quite strongly recognized, or the water use licenses, which are also provided for in the National Water Act. And just going back to Jessica's presentation, I was quite impressed to hear about Namibia's Water Act, which talks about recognizing the customary uses before any licenses can be issued. This is not currently the case in the National Water Act. There is no explicit recognition of customary water tenure, although the National Constitution, Section 211, does talk about customary water law. It is not explicit to customary water tenure. So, agreeing with what Barbara was talking about in terms of investments that happen within customary areas, we find that there are a lot of investments. People invest in pipes to get water from the resource to water their fields. So those investments really are not protected. And if a third party would come and want to get a water use license and exploit a resource, there is nothing to protect those users from securing their access to water. So in that sense, then, we find that customary water uses are invisible and they are given second-class entitlements. So in terms of inequity and injustice in water reform, I just want to look at the fact that the water reform and the land reform processes have generally been carried out in isolation, so one happening outside of the other. And as Jessica mentioned, water rights are very much predicated on other resource rights like fisheries and forests. And we're finding that in South Africa right now, the land reform process is happening alongside, in parallel with the water reform process. So there are some cases where water rights have been removed from the land to which they were attached. And in such a case, you find that communities who then apply to get restituted land, they get that restituted land without the accompanying water rights. And that is a situation that has been identified in some court cases and has set precedent to show that there is that close interaction between land and natural resource rights in terms of customary law, and they cannot be separated. For example, we have one of the famous cases that set a precedent was the Alex Cole versus the Richterveld community, in which the judgment clearly stated that the community had the right to use its water, to use its land for grazing and hunting, and to exploit its natural resources above and below the surface. So it follows that water rights and natural resource rights are quite interconnected and we cannot separate them. So even in terms of the water resource, in terms of the land reform process and the water reform process, there needs to be that connection, the nexus that brings them together. There's another case also where a particular community was given the right to consent, to actually give authority for mining rights to be given within their customary land. So the Baleni community were given that power so that third parties would not come and just get access to mining rights within their customary land. And this was done under the interim protection of informal land rights, which is a provision that is available for the land reform, but not available for the water reform process. So in terms of leveraging the land reform process for the recognition of customary water tenure, we can consider such provisions like the interim protection of informal land rights and apply those provisions to water rights as well. How can we then be able to recognize customary water uses and protect them against third-party exploitation? We also need that clearer recognition of customary land rights compared to the customary rights that exist under statutory law right now. So in the current state, as I've mentioned, the permits and the licenses have more legal standing opposed to the customary water rights that are available. So we have seen that customary land tenure and water tenure are inseparable, but in South Africa at the moment, the two have been separated, and this has led to some practical implications on the implementation of the land and water reform processes. So I would just like to leave it there and hand it over to you, Chair. Thank you.
Thank you very much, Patience. We have now the presentations from all the three speakers. While we're waiting for questions from the audience, I could do maybe ask for comments from any of you in terms of whether there are differences in terms of rights, customary rights, when it comes to groundwater and also the flowing water over geographic areas and across communities. Barbara, you mentioned the fact that sometimes communities actually make arrangements that can you use the water during the day and leave it to flow to us at night. How do these kinds of arrangements, or how do the different types of waters impinge, or does customary living customary rights, how do customary rights vary when it comes to different types of water and the way they are handled?
Am I muted? No.
No, we can hear you.
Okay. It is the same water resource. Water is complex because it falls. It starts as surface water, but then it trickles into the ground. So it is in that sense it is connected, but at the same time the surface water is quite visible. You can make weirs in which you say this portion goes there, this portion goes there, this portion goes there. When you have to share a stream, and groundwater is still under development. Even in South Africa, 10 years ago, nobody talked about groundwater, but we see that. Communities, not only Africa but also India, that they start to learn about how the aquifer, the groundwater table, behaves when more and more people are going to tap water. But it's difficult to understand groundwater. But there are examples that, for example, in arid areas with the pastoralist, if one group has really made a deep well in Ethiopia, so the deep well, then nobody else can drill another well, can make another well nearby. So they call it the zoning. No, this is now the one well, don't get nearer with new infrastructure. But generally, groundwater is more invisible, so it's more difficult to know. But over time, communities learn. And and all for the government as custodian of the nation's water resources. It is really the whole hydrological cycle. Groundwater, surface water, all water is under the custodianship of states.
Yeah, I would just briefly add to what Barbara said, that from a legal perspective, it's a similar answer because it requires infrastructure, even basic shallow wells to access groundwater. That there are some countries in which the regulations are going to make it more difficult for communities to continue to have legally recognized customary rights over groundwater, because that kind of infrastructural development might be legally, a permit might be legally required, whether it's initial building of a borehole or deepening of a borehole, or those the kinds of things require licensing, and so there's a whole sort of I think continuum along which it can be regulated, from accessing surface water for a certain amount without a pump can be exempted from permitting, and usually just for domestic purposes. But that when it comes to any kind of infrastructure, you kind of run into that need to make sure that you're not that the customary water uses are exempted from that permitting requirement. So I think it's a little more common with groundwater, but again, it really varies from country to country.
Yeah, and maybe just to add, one of the practical experiences that I had when I attended one of the land reform forums, community forums, there was just a general consensus that if you drill 6 feet down, then that is okay on customary land. it's fine to do that without having some sort of authorization. I was not too clear on where that sort of anecdotal kind of understanding came from, but it was quite widely accepted. But what also was very interesting for me was that within those forums, there was no clear discussion of customary water rights. So there was a very distinct understanding of what it meant to have your land rights secure, your customary land rights secure, but not for customary water rights, which leaves me to think one of two scenarios. That one, it's kind of implied that once we have the land, then therefore the water also, or there's an understanding that the water is governed elsewhere outside the land. So those were some of the on the ground kind of discussions that I was picking up. Thanks. Back to you, Mafa.
Yeah. Thank you very much. Joy, there's a question from Chuma. Can you put it up for us, please? Can we all see it? Yeah. So says Chuma Mkera, he's asking, I'm from South Africa. I have conducted a study on farmer-led irrigation. Would there be a need for these techniques to be regulated? Do they need licensing of rights? The water resources dams. I'm not so sure whether that is clear. Barbara? And he also adds, how would these permits provision and licensing be possible for rural areas?
Well, thanks so much for raising this key issue, because the National Water Resource Strategy in 2013 itself says that licensing as an administrative, very cumbersome process is inaccessible for the smaller farmers. So the government, the department minister realizes the licensing is just not possible, but then basically we need a solution for that, because now nobody knows. In fact, most people don't even know about it in the former homelands, in farmer-led irrigation development, in the sense that their normative framework is their community, and the community likes it. And if there are problems, we find it within the customary legal system. So it is impossible to do it, but at the same time, formally, you are criminalized if you have more than 0.2 or 0.3 hectares, and people don't know whether it's Schedule 1, etc. So it is the whole need to say customary water tenure needs to be recognized in former homelands. It was recognized before 98, interestingly, and it should be. We should find a solution now. And at the same time, when also farm workers in the former white areas, they also invest in infrastructure. So this is the notion of the core minimum prioritization of water uses. So for the moment, it is the basic human needs reserve says 25 liter, but nobody's implementing it. The patients found that if you ask that question to officials, nobody says, huh? People don't, nobody's really implementing it. And then the next question is, but if basic farmer-led irrigation development for basic nutrition, basic food, basic income, isn't that a priority given the constitutional right to water for food? And then the question then comes how to enforce such a prioritization of water resource allocation for constitutional rights, how to do that.
Yeah. Jessica?
Thank you. I just wanted to add to what Barbara said, that this is something that we found to be common across many countries throughout sub-Saharan Africa and actually globally, that procedural requirements like these in terms of having to be licensed for farmer-led irrigation for, certain quantities of water that were categorized as small-scale productive uses rather than as domestic uses need to be licensed. And regardless of how feasible it is, regardless of how easily the community can afford it in terms of actually paying or the time or the travel it takes to get from wherever they live to undergo the administrative procedures in order to make it happen, it also considerably changes the scope of the water tenure rights of communities, because it places a time limit on what has normally been given as a sort of without right without duration limitations onto it. So, and it prescribes certain uses, it prescribes certain timing, it prescribes certain access points. And so when it comes to, actually licensing customary uses, it fundamentally changes the nature of those customary rights, and in ways that are unfortunately, unrealistic for most governments globally, to be able to implement in any kind of meaningful way when it comes to accessing rural communities. And so I think Barbara is absolutely right that this kind of hybrid water law system, that this approach where we need to come in and say, there's a real need for rethinking these kind of compulsory licensing systems and coming up with administrative procedures that are much more tailored to communities' actual needs and resources is absolutely fundamental.
Come back.
If I can just add, thanks. If I can just add that the inequalities are for the big users, the companies, the government investments, but for the big companies like AMSES, they basically can get the first-class entitlement through a license by just filling in a form. An administrative, and the lawyers know how to fill forms. Yeah. It is enough to get the first-class entitlement, and in other countries, Tanzania, etc., you can even trade it. So by filling a form, the people who know how to deal with administration get a monetary, in the end, then what becomes scarce, get a tradable asset in their hand. And that's clearly administrative injustice according to the Constitution.
And there are even countries, Barbara, there are even countries where they've literally made it more onerous for communities to apply for licenses than it is for business, because they want to attract that kind of investment. There's a great study, I don't have the title of it, but there's a great study that WRI undertook that showed how burdensome comparative requirements were for communities as opposed to a lot of big business in some countries.
Yeah,
absolutely.
Thank you very much. One of the things that also, of course, we are talking about mainly the issue of where you farmers and communities rely on, if you are talking about farming, irrigation water rather than rain-fed farming. But what also fascinates me is the issue of transboundary rivers and resources. And in fisheries, we have this situation whereby you have rivers like Zambezi and the others, the big rivers in Southern Africa, where the resources, the fisheries actually occur in one country compared to other countries, and yet the countries that where these rivers might start from, the communities might not benefit from that fishery because it's out of bounds for them. How do you ensure that rights, those kinds of rights, are protected or they can benefit from those resources? In the marine resources, what the arrangements that are usually made are that fishers from those other countries would have access to such resources in those other countries, if they're able to have that kind of technologies and also the investments. What would be your comment when it comes to transboundary rivers and also the link between the customary rights and also what the AU or the African Union Charter says, and also international conventions say?
I think that's a question for the water lawyer. But I
Yes.
welcome everybody to join in here. No, it's a good question. And the answer really is it depends on the specific treaty regime that governs the watercourse about which you're referring to. So, for example, ZAMCOM, the Zambezi Watercourse Commission Treaty, would govern what happens in terms of sharing of resources, both water and live aquatic resources within, and across the countries. That said, there are general principles of international water law that prioritize equitable and reasonable utilization of those resources. And what that means basically is taking into account a number of different factors that are not necessarily weighted, but including the sort of, the population dependent upon it, their livelihoods needs, sort of all the factors that you were talking about in terms of, weighting these things to say what really is an equitable and reasonable way to share these resources, whether or not they fall strictly within the boundaries of one national territory or flow across those boundaries. And so, if you were within a treaty regime that a country felt didn't really meet with that kind of definition, they could negotiate for different rights. The critical issue I see related to customary and community-based rights is that we actually looked at transboundary due process rights as part of our assessment of customary and community-based water tenure. And there were only, out of 15 countries and all the basins shared in those 15 countries, all the treaties, there were only 2 that mentioned prior notification and consultation with communities as a requirement within the treaty framework. So, participation and consultation to ensure that the rights of communities and customary water rights and customary fishery rights aren't being represented at the national level. And that's the only level really where these consultations are mostly taking place in terms of transboundary negotiations. So there's a big gap there in terms of ensuring much more accountability and participation through transboundary water treaties to ensure that communities' rights are accounted for in those negotiations and discussions. Barbara?
Yeah, I couldn't agree more. Just to add that this is also a field, I think, where Plaas has so clearly shown that the issue is between the big trailers. Then we talk about marine sources, but the big trailers, foreign companies who start fishing and pushing the small-scale fishers out. So rather than we really talk about how is the resource divided, and are we talking about sharing the cake of resources, or are we just we don't want to talk just about who gets the crumbs? We really talk about the sharing of the cake, also with regard to small-scale fisheries.
Yeah, and the benefits that come from those things. Absolutely. Rather than saying there's a limited pie, it's really looking beyond just the resources themselves to what people are benefiting from and those livelihoods gains. And are there other ways to share resources and to come to agreements that enable those benefits to still happen without necessarily depleting the resource?
Absolutely.
Yeah. Thank you very much. We only have about 2 minutes. Can I give each of you 1 minute to say your final comments or wrapping up?
Yeah.
I'll start with Patience.
Okay.
You've been quiet for the last 10 minutes.
Yeah. Thank you, Mafa. I think what I would just want to say is that there's really clear evidence on the ground that there's need to protect customary water tenure. And one way to do that is to leverage the land reform process as much as we can to ensure that those resource rights are integrated more firmly outside of recognizing customary water tenure within the National Water Act itself. That's also one of the recommendations that we put forward, that there should be some explicit recognition of customary water tenure in the National Water Act. But before that can be done, there's the land reform process that we can also use. And one other thing I wanted to say on the comment that was raised by Chuma is that the general authorization has really been put in place to really apply to those small water users. But the threshold that it has been put at the moment is too low, because the administrative burden is there and we can't run away from it. And so I think one of the ways of dealing with that is to give the general authorization a larger threshold, at the same time giving it better legal standing against other provisions such as licenses and permits. Yeah, I think I'll stop there. Thanks, Mafa.
Thank you. Jessica?
Thank you. Thank you, Patience. That was fantastic. And thank you, Barbara, and thank you, Mafa. This has been wonderful. Thank you all for joining us. I guess I would sort of echo what Patience just said and say that there is a tremendous amount of evidence in terms of the intersectoral linkages across land, forest, fisheries, water, in terms of the provisions that impact particularly community-based or collectively held rights and customary rights. And that, you know, if we continue to overlook this, then we're really missing out on a real incredible opportunity to leverage the integration across these different sectors to really meet the basic needs and livelihoods needs for communities globally, not just in South Africa, not just in sub-Saharan Africa, but I think globally is what our study has been showing. And so I would just really stress that we need to be taking a much more integrated approach to tenure reforms more broadly, and then also a real focus on where community-based and customary tenure fits within those processes, and how to better legally recognize those rights and protect them more strongly. Thank you.
Thank you, Jessica. Barbara?
I fully agree. I just echo what Patience and Jessica say, and hoping that also with PLAS as the champion on land reform, that we can continue our collaboration. And thanks a lot for this, hopefully, we haven't been working together, but this continued collaboration with PLAS on the link between the customary land and water tenure, and the redistributive reforms that are urgently needed. Thank you so much.
Thank you very much to our three presenters. As the caption at the bottom says, this is our last webinar for this year. And on behalf of PLAS, we would like to thank all of you viewers and listeners for the engagement and debates that we have had through this forum throughout the year. We hope that these have enriched knowledge and understanding of the various critical issues that have been aired and put up on our website after each of these webinars. We refer you to our website. All of these are available to be viewed after the webinars. We invite you to our next series next year. We'll announce when we start again early next year. We wish you a restful and good break over Christmas. Thank you very much. Bye-bye.